Hello everyone, Advocate Chiranjeev Singh, Legal Associate at NRA Legal Services, is here to apprise you all regarding wills under Indian succession laws. The concept of family is powerful in India. Post the death of a person, their heir can legally take ownership, rights, and obligations of the property left by the deceased through a will. This video will give you a clear understanding of the concept of wills under Indian succession laws. In this video, I will be covering the following topics. Number 1, introduction to wills. Number 2, the wills made in India by NRIs pertaining to Indian properties. Number 3, wills made in India by NRIs pertaining to foreign properties. Number 4, wills made by NRIs in foreign pertaining to Indian properties. Number 5th, wills made by NRIs in foreign pertaining to foreign properties. And lastly, we will be talking about the landmark judgment. So stay tuned until the end so that you do not miss out on any significant information. Will is the legal declaration of the testator's intention on his property which he desires to be carried into effect after his death. Now, simply put, a will is an important legal document that enables any living person to rightfully declare how he intends his assets and wealth to be divided after his death. Making a will can help a person ensure that his wishes about his assets and property are followed dutifully and peacefully after his death. Now, India has a well-developed system of succession laws that governs a person's property after his death. These rules apply expressly to wills and codicils made by Hindus, Buddhists, Sikhs, Jains, Parsis and Christians, but not to Mohammedans, as Muslim law governs their matter. The laws that apply to the making of will are: number 1 is the Indian Succession Act 1925. Number 2 is the Hindu personal laws. Number 3 is the Muslim personal laws. Lastly, we have the Indian Registration Act 1908. Now, persons who are competent to create a will, as per Section 59 of the Indian Succession Act, an individual of sound mind who has reached the age of majority is competent to create a will. The making of a will cannot be done by the following people. Number 1 is lunatics, insane or mentally disturbed persons. Number 2 is minors, that is below 18 years old. When a guardian is appointed to a minor, the age of maturity of such a child is taken as 21 years. Our next topic is preparation of will. Anyone over 18 years of age can produce a will. An individual competent to understand what a will is, what type of property they are dividing, and among whom they are distributing the property can constitute a will. Then we move on to our next topic, essentials of a will. Firstly, the legal declaration. A will is a legal declaration. The documents purporting to a testament or a will must be legal, that is, in compliance with the law, and must be administered by the person legally competent to execute it. It has to be signed and attested as required by the statute. At least 2 witnesses must attest to the will document. Second point is the disposition of property. The declaration should relate to the disposal of assets of the person making the will. Third is the death of the testator. A will becomes enforceable only after the demise of the testator. It gives no rights to the legatee until the testator's passing. Remember, it has no impact during the lifetime of the testator. The testator can change his will at any time before his death in any manner he deems fit. Fourth is the revocability. The essence of every will is that it is revocable during the testator's lifetime. Now we move on to the forms and formalities of making a will. There is no prescribed form of a will. However, for it to be effective, it needs to be correctly signed and attested by the testator. The testator must put his initials at the end of every page and next to any sort of correction and alteration. Then is the language of the will. A will can be written in any language. No technical words need to be used in a will. However, the terms used should be clear so that the testator's intention is reflected in his will. Third is the stamp duty. No stamp duty is required to be paid for executing a will. A will need not be made on a stamp paper. Fourth is the registration. Under Section 18 of the Registration Act, the registration of a will is not compulsory. However, the registration is a strong legal evidence that proper parties had appeared before the registering authorities and the latter had attested the same after ascertaining their identity. A will must be proved duly and validly executed as required by the Indian Succession Act. Once a will is registered, it is placed in the safe custody of the registrar and therefore it cannot be tampered with, destroyed, mutilated or stolen. It shall be released only to the testator himself or after his death to an authorized person who produces the death certificate. Our second topic is wills made in India by NRIs pertaining to Indian properties. There are two types of wills, probated, unprobated. A probate is a copy of will certified by a tribunal. A probate is to be treated as a conclusive evidence of the genuineness of the will. The property can be easily transferred based on a registered will. In some states, unregistered wills are also acceptable for the transfer of property. Next is the process of transferring the property based on a will. For transferring the ownership, the relevant papers are to be submitted in the office of the sub-registrar. The documents required are will. A will can be registered or unregistered. In such a case, a certified copy of the will is submitted. If the will is unregistered, an attested copy of the will is to be submitted. Second is the probate. A probate can be demanded if it is compulsory or if the will is not registered. However, probate is mandatory in certain states. Third is the succession certificate. Even if the will is there but not registered, the claimant through the will is sometimes asked to bring the succession certificate from the court. A succession certificate is generally required for movable property like bank accounts, shares, securities, etc. Then we move on to the admissibility and value of wills in question in litigation matters. Where the will is in question in litigation matters, the will, whether registered or unregistered, needs to be proved as per the requirements of the law. If such a will is to be executed in litigation, then the same can be proved by complying with the requirements of proving the will. Following are the requirements. Number 1, you need the signature of the testator. Number 2, the witnesses must duly attest the will. Number 3, at least one of the witnesses should have appeared before the court, proving the execution of the court. Our third topic is wills made in India by NRIs pertaining to foreign properties. When a will is made by an NRI pertaining to foreign property in India, then the law of the respective country shall prevail. Our fourth topic is wills made by NRIs in foreign pertaining to Indian properties. Wills can be made in relation to Indian properties in a foreign country. The will should preferably be probated to ensure that will is not contested in the Indian courts. It must be attested by 2 attesting witnesses who can prove the contents of the will if required. Next is the admissibility and value of the will in property transfer matters. The property can easily be transferred based on a registered will. In some states, unregistered wills are also acceptable for property transfer. However, Probate is mandatory in foreign will in states like West Bengal, Maharashtra, and Tamil Nadu. Then our next topic is the admissibility and value of wills in litigation matters. The wills, whether registered or unregistered, needs to be proved as per the requirements of the law. If such a will is to be executed in litigation, then the same can be proven by complying with the requirements of proving the will. Then wills made by NRIs in foreign pertaining to foreign properties. In such a case, the law of that country shall prevail for such a will. Lastly, we have our landmark judgment. The Honorable Supreme Court in Lalitaben Jantilal Popat versus Pragnaben Jamnadas Kataria and others held the following. Number 1. The signature of a testator is a must. The witnesses must duly attest the will. Number 3. At least one of the witnesses should have appeared before the court proving the execution of the court. Number 4. If the appearing witnesses fails to prove the attestation by other witness, then he has not been able to prove the validity and legality of the will. Any other witness shall also have to be produced in the court. To conclude, it is safe to say that the execution of a will during the lifetime of a testator is of utmost importance. With this document, the last wishes of the testator can easily be brought out, plus it reduces the chances of family disputes. It also covers the declaration of the entire estate owned by a testator. Further, on the basis of the will, the assets can be given for charity purpose as well after the death of the testator. However, it is highly recommended that after making the will, it should be registered to make it more reliable and a legally strong document. If you have any queries, you can email us at query@nrilegalservices.com. Do not forget to like, comment and share this video. Do subscribe to our channel if you want more such informative videos. Thank you so much for watching.